listening to a live episode of Surviving the Survivor. We bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
What's up, SGS Nation, and welcome to Surviving the Survivor. It is the podcast that brings you the very best guests in all of true crime. Sometimes, like this morning, just the host on trending criminal cases, Shanna Gardner. She is back in a Jacksonville, Florida courtroom today. For those who do not know, she's accused in a case very similar, and this is the court feed. We are looking at Shanna Gardner live. I'm not sure if there's audio yet, but back in February of 2022, Jared Bridegan is traveling with his 2-year-old daughter through a second wife, Kirsten Bridegan, and there's a tire in the middle of the road. Jared gets out to move said tire, and he is then shot and killed. It's very similar to the Dan Markel and Adelson case. And you see now Shanna Gardner's estranged husband, Mario Fernandez Saldana, coming into the courtroom. They are co-conspirators in this case. They both are facing the death penalty potentially in what officials are saying is a very carefully orchestrated ambush. Now, recently, there is a third person that is part of this conspiracy. His name is Henry Tenen, and he was for a while the tenant of Mario Fernandez Saldana in one of his properties. And Henry Tenen admitted to being the trigger man. However, a few weeks back, he said in a court hearing, sort of unprompted, with his defense and the state being totally unaware, he took the reins and said, look, I was forced into some sort of confession. And the judge jumped in, Judge London Kite. And so that's where we are right now in this case. There's been a lot from the defense here, basically pummeling the government. At one point, they said they were looking at confidential information between the defense and their clients, and that the government was unfairly looking at this stuff. So it's been a very up and down, a very interesting case, trial that we're planning to go to, I believe, set to start in October. And again, today is just a case management hearing. So we're going to take a look at that. Now, shout out to True Lifestyles and COE. If you can, Steve is asking for a link for Tim. I think Tim is going to join us. Let me see if I can just get that to him. Everyone just bear with me for a second. Here we go. And here we go. So, True Lifestyles lives in Jacksonville. She's very up on this case, and she's been following it pretty closely. And she sent me an interesting text last night, and I'm going to try to share it with you. Let's see if the COE has this. I'm going to send this to her as well. COE, if you want to pop this up, I'm sending it to you right now. And apologies for the froggy voice. We just, as you guys know, got back from a little Disney trip, and I think the entire family could probably sleep for 10 weeks in a row. So this is an inmate timeline. This is an update on Shanna Gardner, and I'm looking for the date that this was issued, and it looks like I can't read here. I can't see the date, but needless to say, I will read to you, but I have to amend a couple of words in here because it's a little graphic in nature. But Inmate Gardner admitted to cheeking her medication and giving it to inmate Blagman. Contraband was found in her cell, including a fishing line. This next part's a little tough to explain. She had a makeshift sex toy. They use a different word here that starts with a D, ends with an O. So she had a fishing line, a makeshift sex toy that they discovered in her cell, 2 cups of cheeked medication, a torn linen, extra mats, and officer gloves were found upon conducting a shakedown in inmate Gardner's cell. So that is concerning. This is during like a just an update on Shanna Gardner in general. You're looking at Judge London Kite without audio, but again, I will go through this list before we get started. And Space, you just let me know if is there audio, Space? I don't know if it's up yet because this again is a pool camera. Shout out, by the way, to First Coast News. Inmate Gardner admitted to cheeking her medication. I can be honest, I've never really heard that expression. So someone wants to explain what cheeking is. I guess giving, borrowing her medication and giving it to inmate Blagman. Contraband in her cell includes a fishing line, a makeshift sex toy that starts with, they use the word that starts with a D and ends with an O. 2 cups of cheeked medication. Look at Chelsea. It's jail. I guess they're not supposed to have these things. How do you make? You're asking the wrong person. 2 cups of cheek medication, torn linen, which sounds like it could be used to, like, I don't know, a number of different things with torn linen. Extra mats. I'm not sure exactly what that means. And officer gloves. And officers, I guess these like latex type gloves, found upon conducting a shakedown. It's talking about her meals received. Her attitude is calm. Look at Black Widow. When you put your meds in your cheek and don't swallow. And you know what, Black Widow, I knew you were a bright woman. I just didn't realize. Hey, what's up, True Lifestyles? This is Susan Harmon, who knows. And look at this, Mish K, my sister from another, I don't know, somebody. What's up, Tim Jansen? How?
Good morning.
Tim, I'll tell you what, obviously you were not in Disney and the Kennedy Space Center because you look well rested. You look tan, you look relaxed. I'm none of those things. I am exhausted and dead to the world, but we're going to get through this. So Shanna Gardner, Tim, is making, you've done a few of these with us, and she is about to make, she is, we're waiting on this pool camera. She is in a Jacksonville courthouse. We are looking at the seal right here of the great state of Florida. And there's about to be a case management hearing. But Tim, I was just saying, there was a report that was given to us from True Lifestyle. Susan Harmon has been following this case like crazy. And inmate Gardner, there's a few things, and they found contraband in her cell. This is the most recent thing. Admits to cheeking her medication. I'd never heard of that, but Black Widow just explained what that is. Admitted to cheeking her medication and giving it to inmate Blagman. She had contraband, Tim. She had a fishing line in her cell. She had a makeshift sex toy, Tim. They use a different word that starts with D and ends with O.
Right.
She had 2 cups of cheek. Tim took that well. Two cups of cheek medication.
Well, Monica's not on the show today, so
I imagine. Torn linen, extra mats, and officer gloves. And we're just trying to. This is a pool camera, by the way, courtesy First Coast News. The cameraman has apparently Parkinson's here. I'm not sure what's going on. Tim, 2 days running. Yeah. So, Tim,
we're ready to address number 2 on the court's calendar. Mario Fernandez, Saldana.
All right.
Gardner.
And this is the state now. Let's listen in, and then we'll talk about the sex toy and other issues.
okay.
Morning.
Good morning. Good morning. So we're here on several motions and also a case management hearing. And I'm interested in y'all's thoughts, but what I thought we could do is I think it would help in some of the motions that the defense has filed is to give me understanding of where we're at as far as the discovery, what you all
Yeah.
have.
Judge,
Unless there's something that's come up since the time of the filings.
Judge, it's our position on behalf of Ms. Gardner, based on the letter sent by Mr. Khalil, that we are at an all stop.
Letter.
Yes, it was enclosed to Ms. Day's motion that she filed
The one about the reorganization.
and a new drive, that we are at an all stop, Judge. We have made several requests for things that we are outstanding. We're supposed to have a deposition.
Of
We
the
thought
detective.
Johns to sort of go over, like,
Why don't, hold on. Okay. Let's, why don't y'all have a seat? Okay.
This is kind of common. This happens where the parties can't get their act together and they're asking the court to force the other side to do what they're supposed to do.
You can be seated. We're gonna settle down. I need to use a microphone. What is the state's proposal?
She realizes the kids in the sandbox are not playing nice.
Yes, microphone.
Yeah.
Okay.
And this has been a disaster like this up to this point, and it's continuing.
Council and then the state's team, we decided that it would be best that we reorganize. There seemed to have been some confusion as to what exhibits have been tendered, what has been tendered in what format. And so the letter that we sent to council was notifying them of our intent to assist the best that we can. We are going to index the discovery that has been previously tendered in all of the prior discovery pleadings so that everybody would be working off the same sheet of music, that when we were referring to a particular exhibit and a file and the file size and everything, that everybody would have the same understanding. That we are in the process of going through and completing that indexing. My proposal, because I had done it in previous cases where we've had voluminous discovery, is to then provide hard drives with the index and all the materials in the format that are discussed in the index to both councils, and then also file an exhibit with the court. So even the court, when we're arguing motion hearings, would have the same index and have the same materials that would be available for discussions during the course of the motions. It was our understanding after offline and off-record communications with counsel that this would be of assistance to everybody. The other requests that we had made, because Ms. Stifler was getting requests from multiple parties from both defendants' teams, and then also even receiving communications from defense experts about formats that are being received and things of that nature, that we figured it would be better to create an email box. There was an error in the creation of it, but we've now cured that error. An email box for communications, and then also points of contact, so that we weren't responding to multiple people on multiple sides, so that we would bring some sense of order the best we could. Everybody understands that this is voluminous discovery. This was a suggestion and a proposal that we thought would be the best way to sort of try to bring some organization to it. And we're working towards that effort to do that. And we felt that after discussions with counsel would be beneficial to both teams, to the state and to the court moving forward, so that everybody was a little bit more organized. This is obviously a very discovery intensive case.
By the way, I don't remember the last time Jose Baez has been here. He's one of the highest paid attorneys.
You can be
Yeah,
seated.
no, Your Honor.
Use the microphone.
No, Your Honor. Well, and in fact, the first time I heard about it was when Mr. Khalil called me to told me that that's the way that they were moving forward. From Ms. Gardner's position, it was not. We have concerns. we have spent hundreds of hours going through what's been turned over. And we have complained about both the organization of the discovery, the file titling of the discovery, the duplicative disclosures, the vagueness in the discovery exhibits, and now seemingly we are going to have to go through every single thing again to make sure that what the state now proposes is the version we will use for trial is exactly what we've already reviewed. And there is no way for us to do that without opening up each file and confirming things like the page numbers match, that they are the same files. I mean, Judge, we don't know what we don't have, and we've voiced that several times. We've gotten different files that appear to be the same that are not. And I mean, under the law, we have a right to have the discovery, but the manner has been so disorganized with a lack of clarity, as was even pointed out at the last status conference, and what they are turning over, you know, that we're frustrated, Judge. Frankly, we're frustrated. I mean, this is going to delay the trial. There's no other way about it. It's going to increase the man hours that our defense teams, which are privately retained, have to expend just to make sure we know what we have. And it's, you know, the word I would use is frustrating, Judge. It's simply frustrating.
And I see Ms. Day. Ms. Day, you are the contact person for Fernandez, correct? And you're the one that's been going through the discovery, correct?
Yes, Your Honor. And I would echo everything Mr. Carodi just said.
Are you using a microphone? For the benefit of Zoom, you have to use a microphone.
She is.
Okay.
Maybe. The only thing I would add is we've tried this before. Both our firm and Mr. Carodi's firm have previously been provided externals that we were told contained everything that the state had. We have meticulously reviewed the externals, provided list of things that were missing, and then we were told next point was coming, everything would be on next point, and all will be well and good. We got next point, within 2 weeks it was shut down. Then we went back to the externals. Once again, we're told everything will be on there, all will be well and good, just be patient. We get the externals, we do the exact same thing all over again. Then we're told evidence.com will fix everything, just be patient, we'll upload it. Once again, we review thousands of documents, and we're still requesting the same missing discovery that we've been missing since last May.
Mr. Khalil, I know that you are like maybe coming in and offering this as a solution. Sitting in the same position, I don't think it is. I really just don't think it is. So I have printed off, and when I printed off all the state's disclosures, okay, I've printed off the specific demands. I have tried to so I could try to get some type of understanding, lining it up, and it just doesn't. And the same thing that the defense is saying has been the same thing that this has been communicated with the court. I believe the parties can correct me if I'm wrong. I tried to conduct a case management hearing, maybe, y'all correct me, like around December-ish, okay, right before kind of holiday break. And I was told something similar, that hard drives would come in, and I don't necessarily think a hard drive will fix this problem, because I think we're on hard drive number 3, we're on cloud service number 2, and y'all can correct me. I think the defense is objecting to evidence.com because something was inadvertently uploaded yet again.
Ms. Gardner's devices were uploaded.
Ms. Day informed me that she obtained an unredacted copy of one of Ms. Gardner's cell phones that contains attorney-client communications.
It's not going to fix it. So
This is a nightmare.
I'm no lawyer. She's yeah, this is a disaster right now. Now it happened again, they're saying. This is a second incident.
Yeah. It's too bad you can't go back to the old days where you just get paper copies of everything.
hard drives been given to you. You're just keeping them and you're comparing the two.
Judge, it is so voluminous that most of the stuff we have gotten onto our own cloud service, but that's no more than a file share service. And that is at least what Ms. Gardner has done. We can share it amongst our team, but
So you're taking the hard drive that the state has given you and you're uploading it to your own file share service. But so you have now two separate kind of electronic.
we have hard drives and then we have working copies, I would say, on the cloud that people can access and review.
Okay. And forgive me, y'all have to be patient with me because I don't know / I'm trying to get some type of understanding. Okay. So on the hard drive, and I'm gleaning this from a complete overview of what y'all are bringing to the court's attention through motion. And also I'm trying to get an understanding from the state's disclosure. All right. So when you all get the hard drives, how does it correspond to what is in writing by the state?
So, and Ms. Day may be better situated to answer.
Well,
that.
I'll let her take the lead because she's, let Ms. Day.
Yes.
Your Honor, the short answer is it doesn't.
At all?
No. And I have my external and I'm happy to provide it for the court to review it. The court would like.
Which one?
I have our firm's external, but I have a folder on the external in which I've saved every evidence.com as it was received.
Hey, Joel, doesn't she sound like fancy fiction?
Okay, so let's start with one. Okay.
I like this judge a lot. She's very reasonable. She's trying to get
Disclosure.
problem resolved.
There's one that was filed on November 15th,
In Ms.
2023. It has both defendants. This is when the joint indictment at or around that time. So if y'all pull it up, November 15th. So on that particular exhibit, I counted 85 witnesses, category A. Then it is referenced different subparagraphs, right? And then there is a Brady disclosure on that particular document. And to my knowledge, while it was written by Mr. Tassoni that the 6th supplement had Brady information in it, but it was not disclosed Brady, right? The 6th supplement. It was just the notes. Are you with me? The notes from Mr. Chipperfield, but it was not disclosed under a Brady paragraph.
Correct.
But the defense.
That was just the transcript, Judge. The notes came. I may be confused 5th or 6th, but the first disclosure regarding Tenon was just.
No. I'm on the 6th where they give over.
Oh, yes.
Chipperfield's.
I understand. Yes, Judge.
Okay, but it was not identified as Brady.
Yeah. Yes, Judge.
It was just notes.
Yes, Judge.
But what I'm referring to is the writing by Mr. Tassoni, who indicates the defense position is it should have been or is Brady,
Yes, Your Honor.
right? But there's only, what I'm asking, okay, is there's only one Brady disclosure that I'm able to see from the state of Florida, and it is contained within November 15th, right?
Yes, Judge.
So we know what Brady is, right? That's impeaching or exculpatory evidence that the state has to turn over to the defense.
I'm still on November 15th, but I'm comparing back. There is a writing by Mr. Tassoni that there was a reference to Tennant's jail calls in this November 15th disclosure, but I could not find it. It is the subject of Mr. Fernandez's specific discovery request. Where is it in the state's disclosure that they had Tennant's jail calls?
If I remember the disclosures correctly, I don't believe the state's discovery exhibit specifically identified any defendant's jail calls individually. I think it was just listed as jail calls.
Where? Pull it up, Ms. Day. Or the state can pull it up. Because that's one of the things that y'all wrote that you've been asking for essentially since the beginning.
And Your Honor, which pleading are you referring to? The last pleading that was filed 2
Yes.
days ago? Your Honor, the state would request, we just received the pleading and we would request time to respond in writing. I think that would assist in clarifying this. We're not prepared to address all the issues in that motion today.
Okay, I will set aside a different time. Today, I don't necessarily have to hear the motions for sanctions. Today, I can set aside that time. Today, I want to get a full understanding of what just is before y'all start coming up with solutions. And Mr. Khalil, what I'm trying to explain is that this court feels as though if I don't, and then the state then proposes another solution, okay? This is how this case has been going, okay? Which there have been issues brought to this court's attention. I have a relatively short pretrial where everyone says, we have a solution. Then I pass this case off weeks and weeks and weeks, okay? For y'all to get together, for y'all to talk, for y'all to do this. And then what comes of that is more motions, more misunderstandings, more violations of the court's orders, okay? And so my thought is, it may be like, I don't mean to be as methodical, but I've never sat down with y'all. I've never really done this on the record. Every time I ask questions, and I'll give you an example, Ms. Day, if you recall, we were at sidebar, and I thought, I believe it was at the last court date, the state thought that the defense had a searchable a device from the Secret Service. Apparently the state has the ability, with whatever format they have, that they can search, the defense can't. And then you explained to me that what you all were given is if you click on a document, it's a zip file. It takes X amount of time to unzip it. You wait 3 minutes, you wait 20 minutes, you wait 2 hours for it to unzip. And then when you get it, it's some random search on the internet that has nothing to do with anything. And it's a waste of time.
That happened.
It takes us days to download and unzip the files. And oftentimes we open them and it just appears to be computer coding.
I've had that happen.
So the state thinks that you're giving something usable and it's not usable. You take issue with that, Ms. Stifler?
I think some of the issues Ms. Day has brought to my attention at least have been somewhat user error. So some of her
Use the microphone.
Some of these requests I've gotten in her most recent, or the letter that I've responded. They have sent me lists via email. I have responded via email, and in the state's first supplemental demand, in an italicized portion of that demand, I responded to their list. Some of the issues she's raised to me, we've discussed at a discovery conference at our office. Some of the platforms of the information for downloads through Axon or Axiom for the computers are HTML based. So if she opens it, the report goes through a web browser. That's just how it works. That's one clarification I wanted to make. As far as the extractions, we've provided to defense counsel our UFDR files, which they can open through Cellbrite. They also requested the raw data, which I made available to Ms. Day to go to Secret Service and get the raw data for her client. For Bias Firm, their expert has been contacting me directly requesting new copies, first original copies, various formats of different data, and I've complied as best I can to give him what he needs. We have our expert, who is referenced in the letter Mr. Khalil sent, who's going to coordinate with Bias Firm expert, and if Dreiser Hill has an expert as well, to get them the digital data in the formats that they're requesting. So part of it is they're asking me, they're using terms with me like raw data, and I'm giving them what I believe they're asking for. My expert is gathering all these things in one place on all the devices to give it to them in whatever format that they're actually requiring. So they have both the readable version through Cellbrite and the raw data itself. I don't know which one she's looking at. It sounds like she's looking at the raw data if that's how it's opening. But we've provided multiple versions in different formats for these things several times.
When you say raw data, you mean like metadata behind whatever might be, not metadata?
Not metadata.
Okay.
So when you do a forensic extraction on a cellular device or computer, you're copying the information on the phone and decrypting it. You have to parse that data through a software program. For example, a phone, you would use Cellbrite. For a computer information system, in a car, you would use Ivy. You would use Axiom for a computer. So when we provide that to them, we give them the reader. We would give them Cellbrite on the phone extraction so that they can pull the parsed data through Cellbrite, open it, and read it the way you would a regular phone download. Their experts and their firms have also requested the raw data. I presume, and I don't know, that their expert perhaps has some sort of forensic equipment or a physical analyzer that they want to parse the data themselves and make sure it matches up to what we've parsed. So the example that we've been given from Cellbrite is you have flour, eggs, sugar, you have cake batter, and you have a cake. We've provided them the cake, which is the finalized PDF reports. We've provided them the cake batter, which is the UFDR file, so you can run through Cellbrite. And we've provided them the ingredients, which is the raw data.
All right. How are you?
I'm going to respectfully disagree with this.
It's going to get good here soon.
Now for the court that our digital forensics expert had a flight down here on February 25th. He had confirmed the date with Ms. Stifler by email on February 10th. I have the email if the court wants to see it. Ms. Stifler indicated that she would be in trial, but someone from the state can be present. I will have Detective Ostertag reach out to Mr. Green directly, our forensics expert. Detective Ostertag never reached out. Mr. Green was prepared, and it was canceled because the state was unprepared for the meeting on February 25th that they agreed to. So I mean, this is, and our expert has looked at what Ms. Stifler has provided via evidence.com, and that is not what we're asking for. And so the solution was that at our expense, right, we were going to fly our expert in to meet with the state to literally look at it in person, perform whatever methods he needed to perform, and the state canceled. So I think this idea that they're doing everything they can and making sure we get everything we've asked for is not true.
Okay.
The meeting did not happen. I did not cancel it. Mr. Green canceled it because he said he had not heard from Detective Ostertag I reached out to Detective Ostrag and Detective Johns to reach out to Mr. Green, but Mr. Green said he was just going to go ahead and cancel.
That was the day before, Judge, because no one had reached out to him. He wasn't going to get on a plane without being confirmed that he was going to have a fruitful visit here. No one had reached out to Mr. Green after the meeting was confirmed on February 10th. And I've got an email from Mr. Green, bringing this to the state's attention on February 24th that no one has reached out.
Ironically, my life has been user error. Tim, this is just like, does she?
That whatever has been provided, you cannot use it for your defense preparation. I've not looked at it specifically, Judge, because that's why we have an expert, but our expert has told us that is not what we want. Okay.
And Your Honor, I would just add, while we have received several copies of certain devices, oftentimes the file sizes are completely different. So we have no idea if there was a download error, if there are different versions of reports or downloads. We have no confidence that the versions we have are full and complete. We're just wasting our time reviewing incomplete documents that we're going to have to completely redo.
Wow, it's crazy how much she sounds like fancy.
From the point in time that I'm at, which is November 15, 2023, you have no confidence that these things are complete.
For instance, Mr. Tennant has several cell phones. One of them I've gotten 4 or 5 copies of, and all the reports are different sizes. Ms. Jensen's cell phone, I've also gotten 5 different versions of. All of those reports are different sizes. So, and these reports, they're 100 gigabyte reports, they're massive. So to spend time reviewing all of them separately.
What is the explanation of that?
Because we provided them via evidence.com, our next point. If they're down, again, it could be on the user end. If they're downloading it and their computer's running another task, there could be skipping in the data as they download it or an interruption in the download. So I have my forensic expert. He's going to go to the original extractions, rehash all the values, provide the hash values, which is the file size for each original download that's in the possession of the custodian, the original devices, and provide that to defense. We met with him yesterday to get that completed. And Your Honor, just for the court's information, the indexing that we're describing, I have listed these items and provided them. It is not intentional on the part of the state. It is, obviously there's voluminous discovery. I've been attempting to provide them what they're missing. There's difficulty with them receiving things through cloud-based downloads or for transferring. And Ms. Day, and I'm not faulting anybody, but we have sat together multiple times and transferred things from her laptop to my laptop. Neither one of us can control the computer processing and perfection of the download.
I understand. I'm not having any hearing on sanctions. What I'm trying to get to is, so the state is proposing something, right?
Yes,
that you re-index.
I'm going to clarify one thing that Mr. Khalil said. The thought process behind the index and for defense counsel's information as well. And I spoke with Ms. Day about this. I'm not intending to re-provide them all this discovery and say start from scratch. The idea behind the indexing would be that I provide them a number for each exhibit, which would be our working number for trial for our exhibit list, so that that number stays consistent throughout the entirety of litigation up and through trial. So we're all clear what we're talking about. That number corresponds to the name and a sufficient description of that piece of evidence, and that we tag it where it is on evidence.com, what file name it's under, where they can find it, and where it's been previously disclosed in the state's supplementals and original discovery exhibit. So I just want the court to kind of understand the thought process behind the state. It's not giving them a whole new hard drive and indexing it. It's an index of what we've already provided, hopefully to be a roadmap that they can look at Exhibit 643 is Henry Tennant's phone. It was listed in States Exhibit 1 on page 4. It has been provided on evidence.com under subfolder subpoena search warrant returns, titled as this, audit trail showing it was downloaded by defense on this date.
Can I stop you for just a moment?
Yes, ma'am.
So in listening to what they're saying, because the state has provided multiple copies of potentially the same thing, and they're, I guess, concerned that whatever they have is not what the state has / what the state would use, how would that then solve the problem? Additionally, how would that, because from what you all have been telling me, okay, what I'm understanding is that the state has not tagged every single file / thing that they have gotten, and you've been kind of doing it via email or whatever. And then how would you document a second, fast forward, fifth version of whatever they have?
So the evidence.com has an audit trail, which is, and obviously I've sent some things via the portal, which has an electronic trail of what they've received. The responses to their emails and letters have been by email, which I asked Ms. Day in the letter she attached to her filing, or Mr. Tassone's filing. There's a letter with outstanding discovery. I asked her to number it so that I could reply via letter in numerical sequence as well, saying, say number 1 was the HTML issue. I can't get this computer to open it, tries to open a web browser every time I click on it. I would respond, 1, Axiom is a web-based application. It will open a file through a web browser. Item 2, we are missing X subpoena. The subpoena is in the Jack's Beach Police Department Supplemental Report 5 attached. So that's how I was planning on responding to her letter. The indexing, the way that we've organized the discovery on evidence.com is in subfolders. So it's organized under a tag of subpoena. It will have a subpoena and the subpoena return.
Judge, we've never seen that. It comes in similar to the screenshot that Ms. Day attached, where it's just files with a series of numbers. And
Hold on, let me get there, okay?
yes, Judge, like page 16 of 109 in Ms. Day's motion.
And that's what Mr. Dreiser attached about that transcript.
Yes, Judge, they're unlabeled. They're just numbers.
Is that not how it looks for the state?
It's not how it looks for me, but I cannot change the file names of these documents. Some of
Right,
these
but-
electronic documents, because that would be changing
Hold
the
on,
original name.
pause for
file.
just 1 moment. So this screenshot, and I'm looking at 16 Exhibit C, okay? Now I'm looking at 16 and 17. So let's start at 16. It has a series of file folders, right? And then it has a bunch of like various file types and MP4, which I'm assuming is some type of audio, and then a bunch of PDFs.
Yep. And if we want to know what that is, right, we have to open it, determine what it is.
And sometimes the opening, that's what you're saying. Is it a zip or unzip? Like,
We download it as a zip. We have to extract it. When we extract it, this is what it looks like. And then, for example, if I want to know what 2024-1031-105-123-104-282-212-7, I have to open that. I determine what it is. I then have to do a save as, create, if I want to remember, like if I want to find this at a later date, right? I have to do a save as, save a duplicate copy in my own files that this is the transcript of the January 13th Tenon court hearing.
okay.
Because there's no way for me to correlate this to what the state is turning over unless I open it up, review it, and save it under a different name.
Okay, pause. Now, so let's say, Ms. Stifler, look at page 16. on page 16, how does that look to the state of Florida on your end of evidence.com?
The files are categorized in subfiles: subpoena, search warrant,
So
interviews.
they don't have these numbers.
I'm not sure. It's the same way on the CIP when we send discovery through.
I don't know what CIP means.
It's the portal that we use in most cases through the clerk's office. So
Okay.
they sign up for e-service. We go through it. I have no control over how the specific programming titles things when they're sending them.
Okay, go back.
Yes, ma'am.
Is that how it looks to you? Yes or no?
No, ma'am.
Okay. Is there a way for evidence.com for the state to give the defense what you are looking at? Because what y'all solution is not a solution if then you create some index when you're viewing it from the way that you can see it and then giving it to them. And then when they look at an index, then it's just a bunch of numbers and then they're back in the same situation. Do you see what I'm saying? Like if it's not comparing apples to apples.
And Your Honor, if I may add, I think that was the purpose of the hard drive and the cross-reference index is understanding, and again, I'm probably not the best person to be talking about digital evidence. I'm a dinosaur. I'm a paper guy. But when we are talking about this digital evidence, it is being transferred not at the fault of the state, but as a fault of the delivery mechanism in a different view.
Understood.
And so that was our goal in having it in the hard drive so that everybody, when they opened, hypothetically, index number 1, or it's all labeled index number 1 is what we're looking at. So there's not a difference based upon what my evidence.com screen shows and what their evidence.com screen shows. When we open up one, we're all looking at the same document. And we're going to say, when we're looking at that, this is where it was previously tendered under this supplemental discovery response. And this is the data size, how much data, what the size of the file was when it was tendered, and that's the size of the file that it is.
What I'm saying is I don't think that you're hearing them. So y'all could do that on your end. It does not correspond to what they have been able to see. So you all could go down a line and say, this is on, and you all could say, this is subfolder this, it is referenced in state's exhibit, filed on such and such date / such and such date. What they are saying and what y'all are failing to realize is that they have multiple versions of these things. And so they have been saving them as file XYZ. And so if y'all do that with a new index, with a new hard drive, then that is what they are saying that they have to start all over with, because the mechanism that you all have been using has somehow undone, or whatever y'all are looking at just comes in a bunch of numbers / whatever. And so there's no way for y'all, this index, to truly cross-reference for them to make it easier for them.
I'm going to have to speak to Jack Speech about that. Presumably I could get, and with the next point, originally, the idea was it was labeled individually and they couldn't bulk download. They had to download things through subfolders. This gave them the bulk download option because I was told they need a bulk download option.
But then it comes in numbers.
I understand, Judge. My point being, I'm not being difficult. I'm trying to adjust to what they're asking for as best I can. I'm trying to provide it in multiple formats as best I can.
Y'all, look, we're going to I want y'all to just strike all this. Like,
Right.
I'm not doing this intentionally. That is not the purpose of this hearing.
Yeah.
Okay.
A solution that I might propose, but I have to put a pin in this because this involves giving them access and accounts to evidence.com, which Jacksonville Beach Police uses as their case management system. It would be like us giving them a login to Stack. There's like security clearances, there's issues with that. But if there is a way for me to dupe my evidence.com folder into one and remove access to Jacksonville Beach Police case management system for their entire police department.
Who manages this system? Is Jack's Beach or? like whatever this
Yes.
web service is.
Evidence.com is how we receive evidence from some law enforcement agencies. They use it as their case management system. I have an account to access this particular case file in their case management system and to share files with defense counsel. I don't have authority to share access to evidence.com with them because it's the Jacksonville Beach Police internal system.
I'm not suggesting that.
My suggestion is perhaps there's some way I can do this by creating a mirror of their files on my account and sharing it with them with limited access so they can't get into Jacksonville Beach Police case management system. Not that I think they would, but obviously they're.
And Judge, if I may just add this one point, and again, using the paper analogy, this is not foreign. If this was a paper case, hypothetically, and we tendered 1,000 documents and we in discovery, which has been done beforehand, how I label my trial file is not going to mirror how Mr. Carodi labels his trial file. I'm going to label my evidence folders or my witness folders or my evidence in the way I organize, because that's what I do. Even prosecutors across the board don't use the same organizational system. We are providing the discovery. What's difficult is I don't know how we get everybody to organize their trial files in the same way. And I think that's what everybody's trying to do here.
No, that's not it. So from one dinosaur to another, okay? When you have a paper discovery, if you gave it over, you would say property card, sequence number, X with 5 pages. So then when you gave that exhibit over, there is no chance of change. So therefore, you, through the state, to me, this paper is the only thing that really matters. Y'all's emails back and forth, you're this and that, and you say, well, Miss Day, that doesn't mean anything. This is the only thing that means anything. And so then, like, for example, if I go, I'm still on this first one, right? Like if I go to the physical evidence, this should never change value. So paper is different. So if you documented, I gave over this document with this many pages and identify it, then it doesn't matter. I don't think that they're asking for a same trial file, what they are asking for, and that what this court should ensure, because these cases must stand the test of time. It has to be able to be, and I will tell you, like, it is a concern. Like, the different platforms have to be consistent for now and future review. Okay. So this is kind of where I'm at. I don't necessarily think, from what I'm hearing from both sides, that you have to start totally from scratch from either side. What I think needs to happen, and where the state, because we're too far in, right? I think what needs to happen is the defense needs to identify the problematic electronic evidence, and that's where I see the majority of the problems coming. The electronic evidence of the multiple versions. Okay. And I don't know, the hard drives that you all have gotten where you have the problematic electronic evidence, where it's the multiple downloads. What I would ask is that the defense identify those problem downloads. Okay. The problem electronic evidence. That is where we're going to focus, okay, in indexing. Okay, we're not starting from scratch because we're too far along. Then when you all see the problems, and maybe does it have any potential of having like attorney-client privilege, or are you just giving back what they've given you? Or is there a way for you to duplicate how you are seeing it? Do you understand what I'm saying or asking? Okay, so let's say, I don't know what this is because it's just a bunch of numbers. It's Defense Exhibit C, whatever this is, okay? Could the defense somehow duplicate that for the state, give it back? Does that make sense? Like, so y'all have identified, I don't know what this is, these files. Okay. Duplicate it. Say, this is what we want indexed. Is this, what is that? Who is that? This is what we want indexed. Okay. And then the state, you go through and index that and give them back what you are going to use in an index form, what you all are proposing. Does that make sense?
It does, Your Honor.
So y'all are not just going through and saying, we're going to redo everything. It is what they are having problems with. So if they have basically, and if y'all have different values of electronic evidence that you all, maybe it's not on this evidence.com, but you all give them back a hard drive with whatever this is. If y'all have to buy 900 hard drives for each individual thing with an index on it that everyone is working off of, and this is what you're going to use, then minus whatever evidentiary redactions may be needed in the future, but you're giving them exactly what you're going to use, not a download, not a user error, but something that they can plug into a computer and say, this, we can count on that as being what the state is intending to use.
Yes, ma'am. That was the thought process behind this. I told them whatever we indexed or tagged, that would remain the identification number for our exhibit list. That would be what we're using at trial. We're not going to use a different version. That process has begun.
Do you know what their problems are?
Somewhat. I think I have Detective Padilla who is cross-sworn with Jacksonville Sheriff's Office and the Secret Service. I've given him a chart where I have put in one chart all of the devices where the extractions are housed. He's going to the original data. He's going to pull an original copy of raw data and UFDR for all the devices minus their clients. He's going to make a chart with the hash value, file size, and confirm the data is complete and perfected, and provide that list to me and to defense. I will
No,
to defense.
no. They need to identify. You can do that on your own, but like they need to identify where their problems are. And so instead of you doing all of that, you wait for them to say, these are what we have been working on / concerned about. And then you all give back exactly what you're going to use related to those particular devices.
Yes, ma'am. And Ms. Day's provided me a list. I'm working on that. But I only say that for the court to understand that Detective Padilla will be able to give us the confirmed hash value of all these devices. So they can let me know what hash values they have. They can tell me they're missing a download, but if I have to compare it to this list to see if there actually is a problem or if that's the actual file size. That's in process on the state side. Whatever they give me, I'm happy to cross-reference and re-provide. Ms. Day has already given me a list that we've been working on. I did a partial response on state's supplemental discovery 1 to one of her lists. And I told her to, if she numerically listed it, that I would respond numerically as well. And we can file those with the court as a request for discovery and discovery response.
Okay. So that I am, because I mean, I'm not privy, nor do I want to be privy to any of y'all's emails. If the defense would identify through either motion to compel or motion, some type of discovery motion, what you are duplicating / giving to the state as far as problematic. And when I say identify, I mean, let's say I'm just going to hypothetically, it is, I don't know, Henry Tennant's cell phone, like you said earlier, Henry Tennant's cell phone, version 1, 2, 3, however many you've gotten, right? And then you say motion, and then date tendered, then motion to compel Henry Tennant's actual download for what you, that is what you intend to use. It sounds to me that this evidence.com is not a usable / workable format. So I'm not sure. I understand it might be their operating system for like a law enforcement aspect, but for court purposes, it is creating too many problems.
And the benefit to it, Your Honor, just so you understand why we did it, is for the very reason that rather than me plugging their hard drive or flash drive into my computer and transferring something and giving it to them, because I am operating off of, that's the evidence that Jacksonville Beach Police has in their possession, that I have in my possession. They have access to download it. We ensure that we all are looking at the same evidence.
But you're not. You're not. And that's what's creating the problem. And it might be usable for you and law enforcement. It is not usable for the defense. They have been saying now, I think for about 13 months, that they are getting this, and that is not usable. And also for court purposes, for record purposes, it is not corresponding to what I couldn't make heads or tails of this, to be honest with you. Like, this list is wonderful that is on the back of this exhibit listing all the evidence, right? But it doesn't correspond to anything. So, and I understand that you all want to index, which I think is great. Okay. If you all were working along the same lines and you could say on state's exhibit, whatever, this and this, but they are looking at numbers. And unless you know what numbers they have, there is no way for you to properly index it for review where everyone is working off of the same thing. That is what I'm trying to explain. So what I want, and by the next court date, I want the defense to identify the problematic, electronic files and how many versions you all have. To the extent, and you let me know if this is a problem, but, because I'm working in an unfamiliar area, right? So if there is a problem with you all duplicating what they gave you, not anything that y'all, like your work product, right? But what they gave you, you could duplicate it back to them. And then once the state has the problematic evidence, then I'm going to meet with you all, and you can give it to, I'll give you some time. You give it to the expert. And I need to know from whatever law enforcement or whoever, whatever, is able to review it. And I want to know how it is going to be communicated back to them. The way that it is communicated back to them, that is disclosed back to them on black and white paper, will be what it is going to be. So that would ensure, hopefully, that what the state is saying is going to be what will be in this case, period, end of story. Not some cloud manipulated user error download. And I want to know like how big it is or whatever. And if you need to bring these people in, explain to me how it can be disclosed to them in a way that we can all be confident from this day to the last day that it will remain the same. That's what we're going to do. I
understand, Your Honor. And looking at this is the first time Exhibit C, I'm seeing what they're seeing. So
I know, but they have been saying the same thing.
Well, and Judge, I think one way we can do this, and we'll work towards this effort once we receive the problematic list, that's adding another column to our spreadsheet of our index. So we're going to have all that, and then we're going to have their identifying factor corresponding with what our corresponding factor is. That's
so,
really.
I mean, when y'all are looking at these numbers, do y'all have it cross-referenced, or are you just doing what Mr. Carodi said and just changing it to whatever y'all remember it to be?
Change it, but also, as we said many times this morning, because
I can't hear you, Miss Day.
Because we have received so many duplicates, and not just true duplicates, but partial and reorganized and relabeled. It's not just necessarily we download this from evidence.com. I identify this as report supplement 152 and label it as such. I then have to go back through what we have already saved, download, and reorganized to see if it's something that I already received.
Let me ask this, okay, for the defense. Let's say y'all identify the problematic electronic files, okay? And then I would, those, when I say duplicate, meaning that y'all duplicate it for the state, y'all have already gone through these things, correct? Okay.
Well, we've gone through in the sense that we have downloaded and logged that we received it and potentially whether or not there was an issue in opening it. By no means is the defense saying that we've fully reviewed every Google return or cell phone download. That is certainly not true. Okay. I'm asking, okay, for record purposes. So if you all download, or I'm sorry, you all duplicate the problematic electronic evidence, right? Then you send it to the state. You file with the court under seal, okay, for later review if needed, okay? And that seal will mean that those versions 1, 2, 3, 4, 5, however many they are, I would enter an order excluding them. Excluded. So then with the state, you all have the problematic files. You simplify it into the file that will be used. Okay, so whatever gets communicated back, they can count on that is what you are going to use. Okay, not version 1, 2, 3, 4, 5, but this version that you will amend your disclosure back to them. Okay, that will be what it will be. Okay, forevermore. The ones that you all duplicate and file with the court under seal will be excluded from evidence, so that everyone will be working off just whatever you provide this final time. Does that make sense? So then it's not any cross-reference. What my thought process is, okay, is if they give you back what you gave them in these number forms, you can give it to whoever is reviewing this and he can confirm, maybe it is user error, maybe it is some type of interruption, but he can say that, okay, I'm compared these, not them, not their time / expense. You're expert. He compares all this and he says, this is the actual version and give it back to them. Does that make sense?
It does, Your Honor. And
okay, so
you're sort of undertaking that already.
You're not, I know, but like y'all have been telling me this month after month, day after day. And what is occurring is the state is doing this, but it's not being communicated in a way that anyone can be confident that it is the evidence that will be potentially presented. So their investigative purposes. So from that sense, the problematic electronic evidence will be excluded. Whatever y'all identify, it will be communicated back to the state of Florida. Okay. And then what you amend / disclose to them at this point in time is it. Okay. That's it. And then, so like I said earlier with that next point, evidence.com is not workable. Okay, so you all have to find some way. Evidence should not be able to be manipulated. It should not be able to be like you see one thing, they see another. Evidence has to be reliable from all standpoints. And so you can say user error all you want, but we need to get a way that there is no user error. Okay, so by the next court date, It's just going to be, as Mr. Khalil put it, dinosaur. It is what it is. Okay. It's a bone buried in the desert. Okay. It is what it is from this point to the last point. And so evidence.com is not workable. Okay. Unless you can somehow bring someone in here that is going to tell me that they would be able to download whatever without any user error. Okay. So otherwise, if someone is going to tell you that there could be user error, then you need to find another format, either 100 computers or whatever you got going on. Okay. So, anything else about this electronic evidence? So you all are going to identify, that's y'all's to-do list.
Judge, I think that was the purpose of our expert coming down and looking. I mean, we think it's all problematic. And that's why we had wanted our expert to come down, look at the original raw data on the police officers' drives, look at the original devices and say, this is a good copy. And so that was the impetus behind our expert coming down.
Mr. Crody, you're backpedaling. So let's just put all that in the rearview mirror. Okay. Y'all are going to say that this version, that version, this version, you're going to say, we have looked at this, it's problematic. It's got, this megabyte, this terabyte, this, and just dump it. Okay. Then you're going to file it. Okay. So that if needed, y'all will have it. It will be a copy back to the state. It will be a copy to the court, kept under seal. Okay. Your expert will have it. Okay. That will be excluded. You understand? It will not be evidence. Period. You're going to communicate back. They are going to then give you what their final version is, in something that if it's 5 terabytes over here, it will be 5 terabytes over there. So you don't have to worry about it, but you'll have those other copies. So if it becomes necessary, y'all can compare it. You can raise issues. You see what I'm saying?
And their expert, yes, when we complete this, I've already reached out to counsel for future dates. We are happy to do an evidence view with their expert. Once we get this filed and tell them what size the files are, they can examine the original data.
Okay. Do you see what I'm saying?
Yes, sir.
So let's put that in the rearview mirror. And I'll address that if you want to bring it to my attention about this canceling or whatever, but let's just I'm not having any sanctions motion. I'm trying to get to a point where we can move forward. All right. Are you with me or no?
I'm with you, Judge. I don't think you understand the Herculean task that we have been faced with in this case.
I'm trying to
discovery.
I agree.
And now, as I think about this, I understand what the court's trying to do. And I think that if we're just focusing on the devices, there aren't that many devices.
I'm not focusing on devices. I'm focusing on what you all consider problems. Y'all have been telling me that y'all have been wasting time downloading this, downloading that. It takes too long, whatever. Y'all tell me what your problems are. And that's why I cut Mr. Khalil off, because I don't want y'all starting from scratch. We're too far in. What I do want to do is address the problems. If you have multiple versions, they won't be allowed into evidence, but you'll have them. So if y'all want to investigate to see if this final version, that what they are going to be able to potentially use, you'll have it, but it will be for exclusion purposes, a part of the record. Okay. There 9 versions of Henry Tennant's phone will be filed with this court, will be communicated back to them and say, because they are not seeing what you're seeing. Okay. And y'all are seeing 2 different things They think they're solving a problem, but they're creating more problems for you. That is why we have gotten ourselves in this little pickle, okay? Because they keep saying, we're going to do it. And y'all keep saying, when they do it, it's a problem. And it's a big problem because it's a lot of information, a lot of evidence. And so we're scratching all of that. Y'all will still have it. Your expert will still have it. Whatever they give back, that is what your expert needs to look at. Because all that other stuff that y'all have been doing is excluded. The only purpose in it is that when they give you whatever this final version is, y'all have the time, if you want to compare it, but it won't be admitted into evidence the way that it was. So y'all will have some confidence, hopefully, in what this electronic evidence truly is. And I'm not going to let these problems like sit around and fester, okay? If I need to talk to whoever, this evidence.com, this next point, whatever, is a problem. It has been a problem from the outset of this case. And so we need to get into a form where it is rock solid that y'all have confidence that whatever is being communicated is what y'all need to investigate and spend your time on, is where I'm at. Mr. Crody.
Judge, I understand your effort, and we'll comply.
What is the problem with that? Well, you're saying it's a Herculean task, and y'all have already downloaded whatever. I understand all of that. But I mean, otherwise, just sitting around saying it's a problem, what would you suggest?
I have been concerned, and I remain concerned, and I do think that an index would be helpful, okay? I think but if they can compare it to what we've already have, that would be very helpful, because I think while there are problems with the devices, our solution that we had was to send our expert in to get the original data. Like, that was our solution, to make sure that we, on behalf of Ms. Gardner, were not missing anything. Okay, that was our solution. We have not been able to, we know we spoke to the court about that was our plan. We have not been able to accomplish that with regard to the devices.
Okay, well, let me ask you this, okay? If you don't want to do what I am suggesting, and you want the expert just to come in and look at what they have, and then you, Ms. Gardner, leave it the way it is, what Ms. Gardner's issues, I thought y'all had common issues, that is common multiple versions of everything. If you want your expert to go through all the versions that you have gotten and then go through potentially a final version, I'll leave that the way it is. What I'm seeing from Ms. Day is that you like the solution that I've given, which is I will suppress / exclude the multiple versions. You get one version back from the state, and that is what is going forward with Mr. Fernandez. Mr. Crody does not. Y'all don't have to be on the same page. It doesn't.
And I'm not prepared to tell the court right now which way we want to proceed. I don't have the knowledge of what exactly we're dealing with to tell the court which way I want to proceed.
Who's doing the discovery for Ms. Gardner?
There are several people doing the discovery because it's so voluminous, but I think we need to.
Who's the lead on it?
Probably
Ms. Medina
and Ms. Rapetti, but we need to talk to our expert and ask him. I'm just not prepared to tell the court today that's an acceptable solution. I'm just not in a position.
How long is it going to take for you to talk to him?
Probably a few days.
My detective spoke with our expert. He did reach out to him when we got his email before he canceled his trip and asked him what format he wanted everything to be sure. My detective has conveyed that information to me. I've conveyed it to our expert, and we are prepared to gather it in the format he wants and have an evidence view end of April, early May.
In what format?
He wants to look at the data he wants to look at the original extractions on their computer, and he wants a first copy of the original extraction, which we're providing to him. Both the raw data and the parsed data.
Okay. When?
I sent an email to defense counsel. Their expert said he would send us a hard drive because he wanted to look at something before he made the trip down, and I said I sent an email end of April, but I think probably, to be realistic, sometime in May would be best.
No.
Hi, Judge.
Hello.
This is Michelle Medina on behalf of Ms. Gardner, and I'm sorry for the noise on my way to court. But I've been listening. I've been dealing specifically with the digital evidence.
Great.
And the issues that we're having, Judge, we've provided the state with a list of all of the digital forensic evidence that they claim to have in their possession. And I've specified on that list what we just do not have. So it's not an issue of we received one version and we want another, is we do not have it, period. And so the goal was for our expert to just go and just retrieve everything they say they have and just get it directly, instead of having to wait to get a copy, see if it's a readable version, and then relay it back to them. So I think the best way, just for sake of time, is just to have our expert meet with their expert and retrieve the evidence directly. And that,
Miss Medina, you said that you can. How did you give them that list?
in Word format. I actually have that list, and I can provide the court.
Why don't you do it in order to compel? So y'all, Ms. Gardner's issue is not multiple versions.
Well, we have multiple versions as well. This is just it's a side issue of there's evidence that we just do not have that's digital. So it's two.
And it's also, is it the ones that you don't have, meaning that they need a taint review?
No, it's not taint related.
Okay. Well, all right.
I think I'd rather be in prison.
Do you want to?
We're lawyers, and I agree with
hour and a half.
Sometimes it can get lost in translation with the technical terms. That's why even my expert had said, let me just deal directly with your expert, because they understand each other, and just schedule a time and get it directly, you know?
Okay, that I'm fine with that. Okay.
Okay.
But I do want it documented some way.
100%. Yes.
Like I want it documented, whatever you're missing. Okay. So if you'll do that,
yes, Your Honor.
Maybe as a motion to compel. All right. Mr. Carodi is the naysayer in the room about my solution. What do you think about the multiple versions is what I'm working on?
Yeah, no, I think that's a good solution with the multiple versions. My concern was more of what we don't have and delaying that process.
No, I'm not. Okay, we're thinking about different problems. Okay, so I'm on multiple version solution. Okay, multiple version solution, which Ms. Day seems to be signing on to, and Ms. Medina, since you are in charge of it. Okay, which is that. Whatever multiple versions you have of whatever evidence that you then, do you have an issue with the copy being filed with the court under seal? So, but y'all will still have all these versions. So whatever the final version is, you can compare if you want, but you know that those versions would not be admissible. Does that make sense?
Okay.
Are you with me or no?
So you're saying that you would receive a copy of our copy?
No. Y'all would make a copy of what you consider to be problematic. So have you seen the filing by Mr. Tassoni?
Yes.
Okay.
I have.
So what I am gathering from my questioning is that, Mr. Defense Exhibit C on Mr. Tassoni's filing, okay, has, I think, hopefully enlightened the state as to what you all are dealing with.
Yes.
Okay, because whatever they are looking at is not what you are looking at, and then that is what part of the problem is, and they keep trying to solve issues based on what they are looking at, but you are looking at something different. So my thought was, you all make a copy of whatever you all believe to be problematic. And when I'm saying problematic, I'm not saying things that you have not gotten. I'm saying what you have already gotten. Let's say you've got multiple versions. Ms. Day has communicated what one of Mr. Fernandez's issues is that, let's say, and I've been using this as an example. I don't know this to be the case, but Henry Tennant's phone is a 5 terabyte on one version. It's a 3 megabyte.
Yes, that is correct.
I'm sorry?
Yeah, that is true.
Okay. So that's where I'm at. Okay. Are you with me?
Yes.
So that is what you would make, whatever copies you all have received. Okay. You would make the copy of what you all have seen, meaning the numbers / files that has been filed with this court now that make no sense. Okay. That is not what the state sees when they are, I guess, providing it to you, is what I'm gathering. So you all give it back to them. You file it with the court, what you have given to the state saying these are problems. I would exclude it.
Okay.
Okay. So we know that, let's say version 1, 2, 3, 5 terabyte, 3 megabyte, 4, whatever byte. Okay. Is excluded. Y'all would still have it, but the state then amends and would be able to provide you with one version. Okay. That would be indexed, whatever. That is what they're saying in a trial, that this is what it is the day that they provide it to you to the end of days. Okay. That's what my proposal is.
No, I think, I guess my only concern is really the logistics of the copies, because they're huge files.
I mean, why can't, instead of trying to, like what I'm saying, we break these things down into whatever they may be. For example, like, if it's one device, you get one hard drive, not some huge cloud, whatever.
Oh boy. Okay. That's just my I would want to have that conversation with Shannon. Because I think in this format, it can be done with specificity.
Right.
And there's already documents of that specifying, we received this on this date. This was the file name. This is what it shows. I mean, we have that written out. My concern is just providing chunks of the electronic format, just because just downloading it takes hours, sometimes days. So my concern is just now copying it. Could it take just as long? I don't know, is my concern.
I don't understand.
It's like just the digital part, the digital copy.
The reason we did cloud-based nextpointevans.com is because it is a quicker, more likely to download properly and completely than hard drive to hard drive.
All right. This is a capital case. All right.
I understand, Judge.
This is a capital case. This cannot exist in some cloud somewhere. It has to exist of record. These clouds don't exist.
It's just a conduit to deliver the discovery to them. The same way the portal delivers discovery from our office to the
Understood.
office.
Understood. Okay. So let's say down the line, this is a capital case. It has to be filed in a capital way. And so if it's never anything and it's up in some cloud somewhere, that doesn't make any sense to me. Okay.
Which is the reasoning behind the state putting all this on a hard drive index and filing it with the court and then providing copies of that court exhibit to both defense teams, so that at least it's of record. The hard drive that we create and index will be filed as a court exhibit for appellate purposes.
Okay. So if there's ever a question about what they got as a defense team, how do we resolve that issue?
We can take, Your Honor, there's a way to take a screenshot of the, like when you open a hard drive, you'll see all the folders of how we received it from the state. And we could take a screenshot of that folder. It shows, you know, the size of the file. And then we can take a screenshot of that same, let's say, file showing a different size. And that way it's all documented. It's visual. It could be in a list format.
Okay, that's fine. But Ms. Medina, that's not how it looks to them.
Right, but they can see how it looks to us.
Right, but they don't know what to replace it with.
I mean, I would assume that they have what they gave us.
They don't.
You know?
They don't. That is what the problem is. When they look at it, whatever. So we're still operating.
That was me. I'm muting this for 1 second because number one, it's hurting my brain. Number two, I'd rather be in prison. Number three, we are not covering Karen Reed. I can't take it anymore. The most incestuous, vitriolic, crazy trial I've ever seen, and I'm jumping off that bandwagon. So, chat, if there is a trial starts next week that you want us to cover, we are going to have alternative programming to Karen Reed. And then I'm going to let everyone who's following this Karen Reed thing and is so far up their own, you know what, come watch us. So let me know what you guys want instead of Karen Reed. Anything but Karen Reed. Tim did a great job covering it. I just can't take it another second.
And I click on this. It's this with the state.
Your Honor, that quite frankly was our plan for the deposition with Mr. Johnson.
Yes, correct.
We had lots of questions on just how to open files, trying to figure out if they were complete or not. I'm totally understand some of this may be user error and not download error, but I have no way of knowing that without comparing it to a correct and accurate file.
Okay.
Joel, can you save us from this
But
monstrosity we're listening to?
You don't want to start over.
I wish I could.
They're not getting anywhere.
Yeah, I feel like we're going up and down escalator here.
Sorry, Pat. Go ahead.
I think what we're saying, Judge, is going back through the state's discovery exhibits, they have been woefully vague. And I think it would be helpful for everyone if we had a complete index of what the state believes that they have turned over to us. That, for example, going to the paper exam, we have files that say Henry Tennant's jail calls. Okay, that's how they disclose them. We get them and they look like a ton of numbers. Now I know how many files are there, but if they're saying that they disclosed 27 of them, I would like an index that says they've disclosed 27 of them. And so I can go back through, or even more detail, if they're willing to give us more detail. So I can go back through the files that I've received and say, okay, I have 27 calls. What I don't want is for them to give me a new folder that says Henry Tennant's jail calls. I have to click on and say, okay, there are 27 there. And now I have to open my file and say, okay, there are 27 there. Are they the same? That would be, but I do think there is value in an index, and especially if they can relate it back to when they turned it over to us. And then
12:30 p.m. Phil Waters, Phil Ramos, they have like 65, 70 years of homicide experience between them. They're continuing to look at Wendy Adelson's police interview. Ramos filling in for the great Scott Duffy.
That they have.
And provide us an index. And this is probably separate and distinct to the multiple version issue.
Well, we have not even finished that problem, Mr. Carodi.
Yeah, but I do think
Cover Lindsay Shiver.
And I think for
Tim, when does Shiver start?
August 29th.
I say, well,
Oh.
for that at trial. And if the state uses something on that hard drive at trial, we're like, oh my God, we never saw that. They can say, oh, we gave it to you in the hard drive. It's on the hard drive. Well, that makes it that we have to start anew, and that's our objection. What we would prefer the state.
No, that is not what I'm
Hey,
saying.
Joe, maybe we can wrap this up. I got some things I got to get done today.
Does give us detailed
Our dogs have to go
I'm
to
gonna-
get grooming.
Yeah, hold on. I'm gonna mute it. Tim Jansen, I don't even. So we're talking here. By the way, I guess we're probably gonna do Lori Vallow. I think it'll be more interesting by a long shot than Karen Reed. I just can't handle either side, to be honest, on the Karen Reed trial, and there's just no justice. You don't even hear John O'Keefe's name ever, and when you do, it's usually coming from someone who's actually making fun of the family or talking smack about the victim's family. So I just can't take it anymore. So Lori Vallow is going to be handling her own case, and I think we'll do that. COE, do you know when that starts exactly? But Tim, this I don't even know what just happened, other than I'd actually rather be in prison for 3 hours with the Menendez brothers and continue to listen to this. I mean, let me ask you a question, and this is going to be a not a great take for some people, because a lot of people love Judge London Kite, and I think she's good. But has she lost a little bit of control here? Like, does she need to step up? She was getting a little feisty with some of the defense team members, kind of raising her voice at one point. Does she need to just step up and take complete control here and say, "You're doing this, you're doing that, you're doing this. Done. Don't talk back. Don't argue."
Yeah, it's like the umpire in a baseball game that lets you argue balls and strikes. And if you know you can do that, then it gets out of hand. You take 1 yard, you push it. She's a nice judge. She's not taking any control of the courtroom. She should basically tell the parties, okay, I'm going to issue sanctions in 2 weeks. We're going to be back here in 2 weeks. You're going to get together with each other. You're going to get all the documents on some kind of a drive where they can get it, or you can print everything, or you can use flash drives. But I want every piece of discovery that you have to be in the hands of the defense within 2 weeks. And we're going to set a date. You're going to be here, and I'm going to issue sanctions, hold somebody in contempt, but the defense is going to get everything in a format they can defend. This case is going to trial. I don't want to hear about the different formats. Hire a 16-year-old if you need to, who can tell you how to download something, how can transfer things. That's got to be done. You have to push. Lawyers are procrastinators by nature, right? That's why when you go to law school, you get one exam at the end of the year, and people stay up the last week of exam because they're studying, they're procrastinating. Lawyers in practice procrastinate. They do it when they have to do it because they're juggling other things. Stifler needs to stop talking and blaming people. She needs to make sure she wears the white hat. It's a death penalty case. You need to make sure, Stifler, that the defense has every document that they're entitled to. And prosecutors, sometimes they will give discovery. They will not give it in any format. They'll shove it in places to make defense try to find stuff. It wastes time. It's, you're hiding the ball, even though you're complying with the requirements. The best prosecutors are the ones that give everything, show their cards. Defense has it. And if your case is good enough, you're going to beat them anyway. So too many times prosecutors just try to play games, hide the ball. They don't know what Brady is. They believe Brady is really not what they think it is. And it's frustrating. It really is.
Yeah. And Tim, what about the fact, this is a great point from Crime and Contour, it's a capital case. I mean, this is a death penalty case, which makes it even worse. I mean, when the defense first came out today, they said we're at an all stop. They think she's like at an airport. It's essentially a ground stop, Tim. But this is a death penalty case. I mean, which again, I mean, this is the most serious kind of case, and these guys just can't get their act together on either side. Isn't that I don't know, unprofessional at this point?
Well, this is a death penalty case, which means the judge knows that the defense is going to find every which way for an appeal down the road. So if they're going to say they didn't get discovery in a timely manner, they didn't have enough time to prepare, or they never got this document, and then it leads the judge. She's worried about this trial, even they get a conviction being overturned. She's trying to be fair to both sides. I think the state's being a little cavalier in their approach towards the discovery. They need to go out of their way overboard to make sure they have everything, right? So that the defense cannot come back later and say, well, we didn't get this, we didn't know this. And the state, they're carrying the white hat, okay? You have to make sure you go above and beyond. And sometimes you're going to get defense lawyers that play games, sure. But if Stifler can get up there and say, Judge, we did this, and that, they have it. I don't know what format, but they have it. They can review it. And it may not be the same as what we have, but they have every piece of document that we have. And then it's hard for the defense to complain. I get documents sometimes on the computer, and I am a diamond sore. I'm not the great computer person. And I try to open something, I can't open it. I get my assistant, and then they find a way to get it so I can review it in my mind. That can be done. This isn't the largest case ever in volume of documents, so they shouldn't be talking that way. They've got all these lawyers sitting here. They got people with computers right behind them, not even at the tables. They have people and resources to get this done. I don't know why the judge is not pushing them with a deadline. Give them a deadline.
Yeah, well said. I mean, it got to the point where the state had to break this down into a cake analogy, saying that we're giving them the cake batter, the ingredients, blah, blah, blah. By the way, I love the originality of, I never heard of evidence.com. That's what Jacksonville uses there. Very creative. They should have called it Evidence.ly, like every tech company. Evidence.ly.com, not evidence.com. Tim, is the state, do you think, in any way doing this intentionally? That's what someone asked. I thought that was an interesting question.
I hope not. You would hope not. Every time I hear the name Stifler, I think of the movie. That's all I think about is Stifler. And I really couldn't take her serious. And I don't know if I called her Miss Stifler. I know that's juvenile of me, but that poor woman has to go her whole life being called Miss Stifler.
I think she came before the movie, but still, yeah.
At least we need some levity. This was a waste of time. This judge is a nice judge. And I think she can do more control. I don't know if she knows she's on TV and trying to be reasonable, trying to say the right things. But, Judge Hankinson would never put up with this. No federal judge would put up with this. Judge Everett would have given him a deadline and it would have passed. This trial is no way going to go in October. No chance. They don't even have discovery. Their experts not even going to get there till May to get it. Then they have to review it. Then they're going to file motions and they're going to hire experts. This will be trial in 2026, maybe. And that's sad.
So listen, huge thanks again to Tim. He filled in yesterday while we were driving back from the Kennedy Space Center / Disney. It's always a great idea to do a trip like that in the middle of a week where you're trying to work, because I feel so refreshed right now. But yeah, I'm going to let Tim host it yesterday along with Joe Patudo and Melissa Hamilton, who joined him as guests. Tim did a fantastic job and is a lifesaver for me. And Tim is kind of our de facto go-to host when I'm unable to do it. Looks like a lot of people want Lori Vallow instead of Karen Reed. Tim did an amazing job with Karen Reed the first go around, and he was up in Cape Cod. But again, I just can't. So
when that trial starts next week?
Yeah, it starts next week. I believe. Yeah. So everyone, I'm gonna let Tim go. I'm gonna keep this playing for anyone who's a masochist and wants to continue to torture themselves. And I'll be here at 12:30 with Phil and Phil breaking down the Wendy Adelson police interview. Tim, you're the man. I'm gonna pop you out. I'll text you over the weekend. And thank you again for hosting yesterday and joining today.
Hey, Joe, I want you to know I talked to Monica, and Monica agreed we will do a show together.
Oh, awesome.
On your station.
That's some of the best news I've heard right there. You just heard it. Breaking news. Tim Jansen and Monica Jordan to host a show on STS True Crime Talk. True Crime Talk. That is our second channel. Those are all the best guests coming together. So, Tim, you're the man. You'll help us out with Vallow, I'm sure. And while I know you're going to keep tabs on Karen Reed. I'm just going to I'm going to be a Karen Reed instigator is what I'm going to be. Okay, everybody.
I'm father of the bride now, so we're doing all the wedding stuff. So if you see
Yeah.
me sweating, it's because wedding expenses.
That's giving me anxiety. Just listening to that is giving me anxiety. But all right, I'm gonna let us listen to this.
Okay.
Tim, I'll hit you up over the week. Have a great weekend.
Okay.
Man. Bye.
Thanks.
Hill
Bye.
firm. I spoke with the ATF agent yesterday. They had anticipated completing that I gave them a deadline of March. So they know it should be completed shortly. So that's it though.
How was that requested?
I requested they complete the forensic testing by March because
No. So the defense asked that,
there was a particular swab that they wanted DNA testing completed on.
but you didn't file a motion?
I just agreed to it.
Okay.
They can file a motion and you can, for record purposes.
No, I mean, okay.
I'm happy to file, but the state did agree. So
And we had some other swabs
try to
submitted.
save you one.
They had asked for all forensic testing when we had the October trial date be completed
Okay.
6 months ahead. So
No motion needed. Okay. However, what I would like is some documentation, because this is the first I'm hearing of any of that. Okay. There needs to be some type of documentation, either a consent order of
Understood.
what you all, what was requested and what was, or some type of, there needs to be some type of documentation of the request and then the agreement of the evidence that was tested.
I did list the swabs on a supplemental. I can't remember if I parenthesized it requested by defense or not, but I can file something reflecting that. When I receive the testing and disclose it, I can put that in the supplemental.
Okay, that's fine. So whatever evidence was requested by the defense that was tested by agreement by the state, when you get whatever results, that needs to be documented some way.
Yes, Your Honor. That should be shortly forthcoming. ATF, I requested it be completed by March and I followed up yesterday.
Okay. Now,
And
the witnesses.
yes, for Your Honor's information, I'm looking at Ms. Gardner's case. Docket line 318. In December, I had filed a state's exhibit regarding depositions. And
Right. I tried to go through that.
I listed all the depositions we completed in 2024.
Right. And then I did look at that. And then also with some of them were completed later. And then there have been depositions since that time
Yes, Your Honor.
that have not been documented about who was completed. What I'm really asking is what work is left to be done witness wise. Okay. Next court date.
Yes, Your Honor.
I need an outlook for that. But it looks like, I mean, y'all have been working diligently through the witnesses. And the other problem that I wanted to, I'm going to put it out there. I want an answer. The defense has filed requests for specific discovery that is longstanding in this case, and the state needs to respond by the next court date. Do you know what I'm talking about?
I think there was a request for, we had done one filing. I will go back and make sure to respond to all outstanding requests for specific discovery. I think there was a request for some body camera footage in regards to Henry Tennant's arrest on unrelated charges, which I'm happy to provide. And we'll file a response.
I think it's in Mr. Fernandez's case.
The one, all right, then the one I'm referencing is one in Ms. Gardner's case. I'll respond to whatever's outstanding.
It was what I brought up earlier about jail calls that exist. And they also wrote in Mr. Tassoni's filing that they have done a public records request, but to the extent that the state has memorialized those,
Yes, ma'am. And we just have not had an opportunity to respond to Mr. Tassoni's latest filing, and we plan to do so in writing.
But it was referencing what was filed
Yes, ma'am.
way back. So once you all get together, you meet about whatever the multiple evidence, the missing evidence, the consent apparently is not an issue. If the physical evidence has essentially been examined or whatever, I did see that, I guess, some of these experts and things like that have not been scheduled for any deposition yet.
We have not scheduled what I would say would be, the law enforcement that played an integral role in investigating the case.
All right.
That's really who's outstanding.
Okay. And then, but also these forensic experts, both computer.
Correct, because we haven't, we.
Right. Well, I mean, that makes sense.
Yeah, we've been, and the DNA testing's still ongoing.
There's some.
Is there?
Yes, I'm still.
Oh, the ones that were requested.
Yes.
Okay.
It's the same analyst. And there are some experts in regards to cellular site data and location data, FBI and ATF.
Is there any issue with wires?
As far as
we've been spending with the devices.
We're gonna file a motion to suppress the wires because we think it was a bad wire, if that's what the court means.
Okay. I'm not asking, that should have been a better question. What I'm asking is there any issue with disclosure of wires that you all are able to, I'm on discovery, not motion. So is there?
To our knowledge, what I can tell the court is we have received many recorded wire intercepts that.
I saw on one, it's 230.
Yes, Your Honor. And I also provided, they're transcribed. I provided transcripts to defense counsel as well.
Is that disclosed?
No, I didn't specifically list transcripts.
All right.
I can do that.
Look, whatever you are giving over needs to be of record. And so if this is in this master index, that would be great.
That's
Okay.
fine. I'll let the court and defense counsel know I am organizing and planning to file a chart with specific statements of both defendants I plan to introduce at trial. I've been trying to be specific in their statements and my disclosures, but there will be a master list with a motion for pretrial ruling on admissibility for some of the statements in regards to their cases. So they'll have, prior to trial, an outline, all the statements of co-conspirators, all the statements of co-defendants, all the statements of specific statements of defendants I intend to try to introduce at trial.
All right.
And that would include the wires, any digital evidence, reports, interviews, that sort of thing.
So this, I do think the index would be very helpful for everyone. But what I'm trying to do is on the back end of whatever index that you all, before you start creating something new, that you know where the problems lie, so that the index that you all create for whatever reason is addressing their problems. And I know that you all have been trying to address problems, but the problem is that y'all are not on the same page as about what is going on. And so when you get the list of problems that the index, it'll be great. You can say that issue is addressed on index line 1012. Okay. But what I really want to do is address the problems. And so if y'all want to have some master index, great. Okay. But what is at the forefront are these problems, these problematic things, the majority of it is in electronic information.
I understand, Your Honor. I agree. I think it's prudent that we put it in writing in the record instead of just doing emails. And I will say, I want the court to understand, Ms. Day and Ms. Medina have been working very hard and collaboratively with the state. It may not seem that way from this hearing, but I do think that all three of us have been really trying to solve these problems.
I don't take that at all. I think what I do believe is that y'all are somewhat on the same page, but not totally on the same page. And that is, in this court's perspective, very bad. Okay. Very bad, because evidence has to be what it is. And so, like, if people have multiple versions of something, there is no reliability in what is being put forward. There is no reliability in what they were spending their time on. And so what my thought is, and what is so important, especially in a capital case, that it is what it is. And so, like, that's where we've got to get. We are not there yet. I don't think we're necessarily far off. And that's why I want the defense to put not in, but like orders to compel, like, so that it is specifically identified what these problems are. And then I'll get to whatever else y'all want to litigate, but like, so that I have like kind of a clear understanding honed down into what actual electronic files / electronic evidence is, where are the multiple versions, what, that listing, so that I can order responses to it in a timely fashion that does not frustrate the path of this case. So that's why, like, starting all over, I don't necessarily, some of this you are going to have to. But hopefully it will be just on a few things, maybe, not totally. Okay. All right. So how long is it going to take for y'all to do that? And then I want whatever, so that I want the state to confirm that it is 230. That's what I saw in the disclosure, is what it is. Okay. With your index. If y'all don't believe that to be an issue, fine. So disclosure wise, then, the state has disclosed certain subpoenas. I'm assuming that this index would say, like, I know that you have written a supplement disclosure about subpoenas and response / evidence to it. This index will address those issues in a more succinct way.
Yes, Your Honor. And also Ms. Day's number list, I can either incorporate that into an index, or if she's going to file that as a motion to compel, I'll respond specifically. There are times where we sent subpoenas and got no returns, and I tried to file it to reflect that. I know it's hard to disclose that.
Right.
In a way that makes sense.
Right. So I don't necessarily, if you have tried to do it, if it is in the index, that it needs to read almost like a sentence. For example, like I'm looking at, let's say, community first subpoena, date subpoena, whatever it is, no response. And then that should hopefully,
yes, ma'am,
in a line of things, say that this was the date of issue. This is the return date. Result on the subpoenas, because there's so many subpoenas. I counted just on this first disclosure, I think I counted like 40,
yes, ma'am,
44 subpoenas. Okay. And so if the state could line those up in whatever index y'all create for this master, that would be, in my mind, helpful. So we'll just stop it there. So to me, I have two top priorities, which is what will be the focus of the next, which are these multiple versions, so that if you need court intervention about how we would deal with it, if you all show them how it is, like if it's screenshot, great. If it's, you have to actually give it to them, fine. But I'll look to you all to see how you all are able to potentially resolve this. If y'all are able to resolve it on your own, okay. If you need me to exclude / suppress the one and then y'all just start all over, that's what I need to know at the next court date. Okay.
Your Honor, I do have one question. I understand the court's priority is the devices. That is a huge, substantial amount of the evidence. My notes do reflect there are about 198 subpoenas, and I do believe.
Well, I was only looking at that one exhibit. So.
I have them all listed. I do believe we are missing about half. So.
Okay.
We see it as like an equal concern to the devices.
Subpoenas.
Yes.
Okay, got it.
So I didn't know.
All right, so do that in a motion to compel. You list what, have you all referenced, like, let's say subpoena A has a result and you have that? So the devices or the subpoenas where you don't have corresponding response, list that in a motion to compel and put the state on notice.
Okay.
Okay.
Yes.
Not an email.
Yes, Your Honor.
Okay. So then everyone is operating on the same page and the state can go through whatever, and then we'll deal with how they have responded or how they intend to respond. If they have no response or what. How long do y'all need to do that? And don't say 30 days.
I know. I'm in a all-week trial next week.
Can someone else help?
Yes, we have a paralegal who's working on this with us.
As soon as we get the list of, Your Honor,
Right.
of what they believe.
Microphone. Microphone.
Oh, I apologize. As soon as we get the list of what they believe they need in the motion to compel, we will.
How long do you think? From the defense, how long will it take for you to compile it?
I guess.
And do it in do one. Okay. So from this hearing, this is what is missing, right? And do it just in sections. So then it can be communicated in the state and we can then deal with those.
Your Honor, my hope is that we have scheduled a discovery conference on April 17th amongst the parties. We hopefully will be able to have the answers by that time. If not sooner.
All right, you're just shy of 30 days then when I could probably do this again. All right, the other thing, so if you all are going to have those conversations, okay, if it becomes necessary from y'all's perspective to just have the experts talk to one another, or schedule on-site collection or what, I don't know what y'all want to call that. I don't know. If you all will select a date and time, I'll put it in order. So then there's some teeth behind it. Okay.
Yes, sir.
Perfect. Thank you, Your Honor.
I mean, I'm operating a little bit in the dark because I don't know what these things are. I don't know kind of what it takes, but if you all I appreciate y'all's patience with me because I'm trying to understand it, but as to the extent that this court can help kind of unravel some of these issues, I'm happy to do that. And y'all, what I do intend to do from this hearing is designate this as a priority case. And as a priority case, it would take precedent over anything I have on my calendar. So if you all need me, I will make myself available at a drop of a dime. Okay. So there it is. Courts, actually the chief judge has made this a priority case. I will incorporate that / memorialize it in order, so that you all know that if you need me, I will be here. You will have the court time. I don't want these problems or miscommunication or whatever might be occurring to fester for days and days and days. If y'all get to a meeting and you can't get it resolved, you can have time with me the next day. Okay. I do not want these things to kind of go like this. We need to, and to me, it takes maybe sitting down, hashing it out, and then I will intervene if I need to. I'm not going to intervene if I don't need to. So I will do that so that you all know whenever you need this court, I will be here. Okay. All right. Thank y'all for your time. Do you all have time? I have something, but I will reschedule it as I've indicated, maybe April 25th after y'all's meeting.
I'm out of the country that week, Your Honor.
Okay. The date and time, how written in stone is that April 17th date of a discovery meeting? I say I come before that. I can come in before that
Yes, ma'am.
to get answers. So I'm available next week. I'm available the week of April 7th, and y'all tell me a time. Isn't the bias firm unavailable?
Through April.
I believe it was April 1st,
First.
Judge. I know I'm unavailable the 9th, 10th, and 11th doing the death penalty CLE, so I need to get those hours for my certification.
All right.
Your Honor, I'm in an all-week trial next week, but maybe April 8th, that Tuesday.
Okay.
So the dates again were April 8th, 9th, and 11th?
Mr. Corradi said he's unavailable the 9th, 10th, and 11th. He's in a death penalty CLE. So right now, y'all can have plenty of time with me next week.
I think Ms. Stifler said she was
Oh, she's in a trial.
I'm in a trial in front of Judge.
There's
Saldana.
nobody else that could just get answers.
I can get answers and relay them to co-counsel. If that's when Your Honor wants to set it, somebody can be available.
the 8th I think the 8th would work.
If we do the 8th, I'd have to do early morning because I have 4 trials set. One is a speedy issue. So I could do special set at 8 a.m.
I can do that.
Statesville.
Yes.
Yes, Your Honor.
All right. Y'all got it. April 8th, 8 a.m. special set. Case management hearing.
That's to see where we are in the devices.
Yes. And then from that point, once y'all hopefully have figured that out, if y'all want to proceed with the sanctions and things of that nature, I would schedule at that point. That will give the state time to review Mr. Tissoni's latest filing. And y'all can tell me, and if you want partial review, or you let me know at that point in time and I'll schedule the hearing. Okay.
Yes, Your Honor.
And one last update, we did receive an email late yesterday from Mr. Gano. He was able to complete the filter procedure on Ms. Gardner's Apple iCloud, and he is prepared to send that to defense counsel for review.
I thought it was the phone.
When he says Apple phone, he means Apple iCloud, I believe.
I guess we'll see when we see it.
See, y'all are talking 2 different languages. All right. See you.
Phone.
All right. We'll see y'all next time. April 8th, 8 a.m.
There you have it. If this was not exciting and riveting enough for you, you get another case management hearing on April 8th. Hopefully they'll get their proverbial ducks in a row. We will be back today at 12:30 p.m. Eastern time in about an hour and I don't know, 17 minutes or so with the two Phils, both homicide detectives, retired, who are going to be breaking down the Wendy Adelson interview. We will see you then. Love you, America. Love you, Jacksonville. And justice for Jared Bridegan in this case. There he is. There he is. See how he's making us dizzy. See you at 12:30, everybody.